Hello and welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Like, subscribe, and click the notification bell so you can be updated every time we upload new content, which is usually every day at 8 a.m. Eastern Standard Time. Here's our first question for today. Defendant is on trial for breaking and entering into a warehouse at nighttime. The warehouse owner had set up a camera to take infrared pictures of any intruders. After an expert establishes the reliability of infrared photography, the prosecutor offers the authenticated infrared picture of the intruder to show the similarities to the defendant. The photograph is A. Admissible, provided an expert witness points out to the jury the similarities between the person in the photograph and the defendant. B. Admissible, allowing the jury to compare the person in the photograph and the defendant. C. Inadmissible, because there was no eyewitness to the scene available to authenticate the photograph. Or D. Inadmissible, because infrared photography deprives the defendant of the right to confront their witness. Take 10 seconds. If you chose B, admissible, allowing the jury to compare the person in the photograph and the defendant, you'd be correct. Every item of non-testimonial evidence must be authenticated in order to prove that the proponent of the evidence claims it to be. In this case, the authenticated infrared picture of the intruder is offered to show the similarities to the defendant. Once the infrared picture is authenticated, it is admissible without further testimony, and the jury can decide how similar the pictured intruder is to the defendant. Thus, the photograph is admissible, allowing the jury to compare the person in the photograph and the defendant. I once sat in on a trial where the defendant was charged with murder and there was a videotape presented of the crime. The individual in the videotape was a bit blurry, and the prosecutor, in essence, argued that the dimensions of the defendant's body met the dimensions of the individual in the video. In essence, that they were one and the same because their physical similarities were the same. Let's move on to question number 2. Owen owned Blackacre in fee simple, as the land record showed. When he contracted to sell Blackacre to Breyer 2 weeks later, Breyer paid the agreed price and received a warranty deed. A week thereafter, when neither the contract nor the deed had been recorded, and while Owen remained in possession of Blackacre, Cred properly filed her money judgment against Owen. She knew nothing of Breyer's interests. A statute in the jurisdiction provides any judgment properly filed shall for 10 years from the filing be a lien on the real property then owned or subsequently acquired by any person against whom the judgment is rendered. The Recording Act of the jurisdiction provides, no conveyance or mortgage of real property shall be good against subsequent purchasers for value and without notice unless the same be recorded according to law. Cred brought an appropriate action to enforce her lien against Blackacre in Breyer's hands. If the court decides for Breyer, it will most probably be because A. The doctrine of equitable conversion applies. B. The Jurisdiction's Recording Act does not protect creditors. C. Owen's possession gave Cred constructive notice of Breyer's interest. Or D. Breyer was a purchaser without notice. Take 10 seconds and choose the best option. The best option here is B. The Jurisdiction's Recording Act does not protect creditors. The Recording Act of the jurisdiction provides no conveyance or mortgage of real property shall be good against subsequent purchasers for value and without notice unless the same be recorded according to the law. If the Recording Act does not protect creditors, then Cred cannot rely on the fact that Breyer did not properly record the conveyance of real property to enforce her lien against Blackacre. If the court decides for Breyer, it would be because the language of the Recording Act does not extend to creditors. Question number 3. The warden of a state prison prohibits the photographing of the face of any prisoner without the prisoner's consent. A news photographer, wanted to photograph Mobster, a notorious organized crime figure incarcerated at state prison. To circumvent the warden's prohibition, photographer flew over the prison exercise yard and photographed Mobster. Prisoner, who was imprisoned for a technical violation of a regulatory statute, happened to be standing next to Mobster when the photograph was taken. When the picture appeared in the press, prisoner suffered severe emotional distress because he believed his business associates and friends would think he was consorting with gangsters. Prisoner suffered no physical harm as a result of his emotional distress. Prisoner brought an action against photographer for intentional or reckless infliction of emotional distress. What is the best argument that photographer can make in support of a motion for summary judgment? Here are your four options. A. No reasonable person could conclude that photographer intended to photograph prisoner. B. Prisoner did not suffer any physical injury arising from the emotional distress. C. As a news photographer, photographer was privileged to take photographs that others could not. Or D. No reasonable person could conclude that photographer's conduct was extreme and outrageous as to prisoner. Take 10 seconds and choose the best answer now. If you chose option D, you'd be correct. No reasonable person could conclude that photographer's conduct was extreme and dangerous as to prisoner. Intentional reckless infliction of emotional distress requires 1. Intentional or reckless infliction. 2. Severe emotional or mental distress. 3. An extreme and outrageous conduct. 4. Actual damages. And 5. Causation. In this case, photographer flew over the prison exercise yard and photographed mobster and prisoner, who happened to be standing next to mobster when the photo was taken. However, in order for prisoner to recover for intentional or reckless infliction of emotional distress, photographer's conduct must have been extreme and outrageous. Taking a photograph generally cannot be considered extreme and outrageous conduct. As such, photographer's best argument in support of a motion for summary judgment would be that no reasonable person could conclude that photographer's conduct was extreme and outrageous as to prisoner. Let's move on to question number 4. Scott held up a drugstore at 10:30 at night and drove away. His car broke down in an isolated area just outside the small city in which the crime occurred. Scott walked to the nearest house and asked Henry, the homeowner, if he could stay until the next morning, explaining that he had been searching for his sister's home and had run out of gas. Henry agreed to let him sleep on a couch in the basement. During the course of the night, Henry began to doubt the story Scott had told him. Early the next morning, Henry called the police and said he was suspicious and frightened of a stranger whom he had allowed to stay the night. The police went immediately to the house to assist Henry and walked through the open front door. They found Scott and Henry drinking coffee in the kitchen. When they saw Scott, they realized he matched the description of the drugstore robber. They arrested Scott and his jacket. They found drugs taken during the robbery. Scott moves to suppress the evidence of the drugs. If the court finds that the police did not have probable cause to believe Scott was the robber until they saw him inside of Henry's house and realized he matched the description, the court should A. Grant the motion, because as a guest, Scott has sufficient standing to contest the entry of the house without a warrant. B. Grant the motion, because as a guest, Scott has sufficient standing to contest the lack of probable cause at the time of the entry. C. Deny the motion, because Scott had no ownership or other possessory interest in the premises. Or D. Deny the motion, because the police had the permission of the owner to enter the house. Take 10 seconds and choose the best option now. If you chose option D, you'd be correct. Deny the motion because the police had the permission of the homeowner to enter the house. The Fourth Amendment prohibits unreasonable searches and seizures. Unreasonable searches and seizures intrude upon an individual's reasonable expectation of privacy. The purpose of the Fourth Amendment is to prevent police and law enforcement misconduct. Generally, a warrant is required under the Fourth Amendment for the police to conduct a search, but there are exceptions to this warrant requirement. One such exception is voluntary and intelligent consent to the search. In this case, the fact that Scott was an overnight guest is a distractor because it seems to implicate the issue of the Fourth Amendment and standing. This, however, overlooks the fact that the homeowner called the police the next morning and said that he was suspicious and frightened of the stranger who stayed overnight. When the police arrived, the front door was open and the police entered already having the homeowner's valid consent. Probable cause regarding Scott's identity was not necessary at the time of the police entry. The spirit of the Fourth Amendment is to prevent unreasonable police conduct. In this case, the police acted reasonably by going into the house to assist the homeowner. When the police recognized Scott as a drugstore robber, the police had probable cause to arrest him, and a search of his person that was conducted incident to this lawful arrest revealed the drugs taken during the robbery. Therefore, the court should deny Scott's motion to suppress the evidence of the drugs. Let's take a look at some of the other options. Option A, grant the motion because as a guest, Scott has sufficient standing to contest the entry of the house without a warrant. This is absolutely inaccurate, as generally it's not just an overnight stay as a guest in someone's home, which gives rise to property rights, and especially property rights such as this to enter a home. B, grant the motion because as a guest, Scott has sufficient standing to contest the lack of probable cause at the time of the entry. If there is an issue with probable cause, he has every right to bring that up. However, given the fact that the police were actually, in fact, invited by the homeowner himself, that is a bit of a problem as to this argument. C, deny the motion because Scott had no ownership or other possessory interests in the premises. This is, in fact, actually accurate to some degree. However, the issue is not whether Scott had the right to stop the police from coming into the premises, more so searching his person. This is where C goes awry. It, in essence, misses the major point of the question and the fact pattern. Question number 5. A written construction contract began with the following recital. This agreement between Land Inc., hereinafter called owner, and Builder Inc., and boss, its president, hereafter called contractor, witnesseth the signatures to the contract appeared in the following format. Land Inc. by Oscar Land, President, Builder Inc. by George Mason, Vice President. Mary Boss, President, Mary Boss. Builder Inc. became insolvent and defaulted. Land Inc. sued Boss individually for the breach, and at the trial, Boss proffered evidence from the pre-contract negotiations that only Builder Inc. was to be legally responsible for performing the contract. If the court finds the contract to be completely integrated, is Boss's proffered evidence admissible? A, yes, because the writing is ambiguous as to whether or not Boss was intended individually to be a contracting party. B, yes, because the evidence would contradict neither the recital nor the form of Boss's signature. C, no, because the legal effect of Boss's signature cannot be altered by evidence of prior understandings. D, no, because of the application of the Four Corners rule, under which the meaning of a completely integrated contract must be ascertained solely from its terms. Take 10 seconds and choose the best option. If you chose option A, you'd be correct, yes, because the writing is ambiguous as to whether or not Boss was intended individually to be a contracting party. The parole evidence rule states that no prior expressions or contemporaneous oral statements are admissible to contradict the final integration between the parties. For the parole evidence rule to apply, there must be an integration, i.e. a written agreement intended to be the final contract between the parties. Integration can be complete or partial. While parole evidence is inadmissible to contradict, it is admissible for both partial or complete integrations. 1. To show a clerical error. 2. To show a defense to contract formation. 3. To clarify ambiguous terms. 4. To show a consistent collateral contract. And 5. To show the existence of a condition precedent. In this case, the court has found a completely integrated contract, so the parole evidence rule would apply. Boss is attempting to proffer evidence from the pre-contract negotiations that only Builder Inc. was to be legally responsible for performing the contract. Since the written contract is ambiguous as to whether Boss signed this contract in her individual capacity or solely as the president of Builder, parole evidence would be admissible to explain or interpret ambiguous terms in the contract. As such, Boss's proffered evidence would be admissible. Now, if you look at option B, yes, because the evidence would contradict neither the recital nor the form of Boss's signature. the response actually makes no logical sense, as it seemingly contradicts the facts in and of themselves. Now, if we look at option C, no, because the legal effect of boss's signature cannot be altered by evidence of prior understandings. Again, C misses the point, as we're not looking at the alteration of the signature, but the understanding of the agreement as a whole. And now, D, no, because the application of the four corners rule, under which the meaning of a completely integrated contract must be ascertained solely from its own terms. In fact, that is an misaccurate statement. Generally, parole evidence is permitted to clarify the understanding of the four corners rule. Question number 6. Defendant's on trial for extorting $10,000 from victim. An issue is the identification of the person who made a telephone call to victim. Victim is prepared to testify that the caller had a distinctive accent like defendant's, but that he cannot positively identify the voice as defendant's. Victim recorded the call, but has not brought the tape to court, although its existence is known to the defendant. Victim's testimony is A, inadmissible because victim cannot sufficiently identify the caller. B, inadmissible because the tape recording of the conversation is the best evidence itself. C, admissible because defendant waived the best evidence rule by failing to subpoena the tape. Or D, admissible because victim's lack of certainty goes to the weight to be given to the victim's testimony, not to its admissibility. Take 10 seconds and choose the best option. If you chose option D, you'd be correct, admissible, because victim's lack of certainty goes to the weight of the evidence, not to the admissibility. The authentication requirement for an item of evidence is met if the proponent produces evidence showing the item is what the proponent claims it to be. Under the federal rules of evidence, an opinion identifying a person's voice based on hearing the voice at any time under any circumstances that connect it with the alleged speaker satisfies the authentication requirement. Here, victim is prepared to testify that the caller had a distinctive accent like defendant's, but victim cannot positively identify the voice as defendant's. This testimony is admissible as an opinion identifying defendant's voice, and the fact finder can decide how much weight to give to this testimony. Therefore, victim's testimony is admissible because victim's lack of certainty goes to the weight to be given the victim's testimony, not its admissibility. If you look at option A, inadmissible because victim cannot sufficiently identify the caller, the answer in D, in essence, contradicts A in its entirety, and the reality is, as noted, the correct answer is that the issue of identification will be one of weight of the evidence as opposed to admissibility. If we look at B, inadmissible because the tape recording of the conversation is the best evidence. While that is accurate and that can be introduced as evidence to permit the jury to themselves distinguish between the voice in the audio tape and the voice of the defendant, if they hear the defendant speaking, that is, the question here is as to the oral statement, not as to the recording itself, so B misses the point. C, admissible because defendant waived the best evidence rule by failing to subpoena the tape. Irrelevant, I can't even logically understand what C in fact means, because the best evidence rule does not require the subpoenaing of a tape or an item. It's simply here, especially in a criminal matter, given the fact that the victim recorded the audio. In fact, the audio would be in his own possession. So C would be irrelevant, and as a result, D would be the best option. Question number 7. Vintner is the owner of a large vineyard and offers balloon rides to visitors who wish to tour the grounds from the air. During one of the rides, Vintner was forced to make a crash landing on his own property. Without Vintner's knowledge or consent, Trespasser had entered the vineyard to camp for a couple of days. Trespasser was injured when he was hit by the basket of the descending balloon. If Trespasser sues Vintner to recover damages for his injury, will Trespasser prevail? A, no, unless the crash landing was made necessary by negligence on Vintner's part. B, no, unless Vintner could have prevented the injury to Trespasser after becoming aware of trespassers' presence. C. Yes, because even a trespasser may recover for injuries caused by an abnormally dangerous activity. Or D. Yes, if the accident occurred at a place which Vintner knew was frequented by intruders. Take 10 seconds and choose the best option now. If you chose option B, you'd be correct. No, unless Vintner could have prevented the injury to trespasser after becoming aware of trespassers' presence. There is no duty of care owed to undiscovered trespassers because undiscovered trespassers are unforeseeable victims. However, if discovered, an owner of land owes the trespasser a duty of reasonable care. In this case, trespasser was undiscovered, so Vintner would not be liable unless he could have prevented the injury to trespasser after becoming aware of trespassers' presence. Please note that this answer choice is a bit strange because it is basically saying trespasser was undiscovered unless he was discovered. Let's look at option A. No, unless the crash landing was made necessary by negligence on Vintner's part. Even if Vintner had been negligent and the crash was caused by his negligence, if he did not know of or was not aware of trespassers' presence, there's no possible logical leap which would cause legal responsibility for his injury. Let's look at C. Yes, because even a trespasser may recover for injuries caused by an abnormally dangerous activity. Again, C misses the point in noting that if the landowner is not aware, if Vintner is not aware of trespassers' presence, it is impossible for him to be deemed responsible for any injury to that person. And we're not looking at a situation where rifles or guns or shotguns were placed in order to protect property and purposely aimed towards shooting intruders or anything of the like. Here, there was no clear mens rea or no clear intention for a trespasser to be injured or to be hurt. It was simply an accident. And finally, D, yes, if the accident occurred at a place which Vintner knew was frequented by intruders. Again, B is the more correct answer because it specifies that he has actual knowledge of particular location of trespasser and ignores that information and then intentionally, in essence, injures trespasser. As a result, B would be the best answer because, in essence, B would create intention. Question number 8. Susan entered a guilty plea to a charge of embezzlement. Her attorney hired a retired probation officer as a consultant to gather information for the preparation of a sentencing plan for Susan that would avoid jail. For that purpose, the consultant interviewed Susan for 3 hours. Thereafter, the prosecution undertook an investigation of Susan's possible involvement in other acts of embezzlement. The consultant was subpoenaed to testify before a grand jury. The consultant refused to answer any questions concerning her conversation with Susan. The prosecution has moved for an order requiring her to answer those questions. The motion should be A. Denied on the basis of the attorney-client privilege. B. Denied in the absence of probable cause to believe the interview developed evidence relevant to the grand jury's inquiry. C. Granted because the consultant is not an attorney. D. Granted because exclusionary evidentiary rules do not apply in grand jury proceedings. Take 10 seconds. If you chose option A, denied on the basis of the attorney-client privilege, you'd be correct. The rule is that any communication between attorney and client or their representatives intended by the client to be confidential and made in an effort to obtain professional legal services is privileged in all criminal and civil proceedings unless the privilege is waived by the client. In this case, the probation officer was hired as a consultant by Susan's attorney to gather information for the preparation of a sentencing plan. As such, this communication is protected by the attorney-client privilege. The general rule is that anything and everyone which your attorney hires or brings into play is an extension of that office, regardless of the hiring of this consultant, which is clearly an individual that is outside of the scope of this attorney's everyday office. The extension is still granted, and that individual who is independently hired is still deemed an extension of the attorney's office. If you look at option B, denied in the absence of probable cause to believe the interview developed evidence relevant to the grand jury's inquiry. Brutally honest, I don't even understand what that answer means, so I would avoid it like the plague. C, granted because the consultant is not an attorney. Again, not relevant because although he is not an attorney, not only attorneys are covered under the attorney-client privilege. For example, conversations with the paralegal at the office or the receptionist all would arguably be covered under your attorney-client privilege. Any conversation with a paralegal or any notes that paralegal makes, those would all be covered under attorney-client privilege. D, granted because exclusionary evidentiary rules do not apply in grand jury proceedings. So D misses the point entirely. It's talking about grand jury proceedings, which are generally for the purpose of establishing whether a felony occurred. Here, the fact pattern is talking about sentencing, which is a completely different stage of the criminal proceedings. As such, D is not relevant, and A is the best option. Question number 9. Fixtures, Inc., in assigned writing, contracted with apartments for the sale to apartments of 50 identical sets of specified bathroom fixtures, 25 sets to be delivered on March 1st, and the remaining 25 sets on April 1st. The agreement did not specify the place of delivery or the time or place of payment. Which of the following statements is correct? A. Fixtures must tender 25 sets to apartments at apartments' place of business on March 1st, but does not have to turn them over to apartments until apartment pays the contract price for the 25 sets. B. Fixtures has no duty to deliver the 25 sets on March 1st at Fixtures' place of business unless apartments tenders the contract price for the 25 sets on that date. C. Fixtures must deliver 25 sets on March 1st, and apartments must pay the contract price for the 25 sets within a reasonable time after their delivery. Or D. Fixtures must deliver 25 sets on March 1st, but apartments' payment is due only upon the delivery of all 50 sets. Take 10 seconds. If you chose option B, you'd be correct. Fixtures has no duty to deliver the 25 sets on March 1st at Fixtures' place of business unless apartments tenders the contract price for the 25 sets on that date. The general rule is that for an exclusionary contract where simultaneous performance is possible, each party must first tender performance before a duty will be imposed on the other party to perform. In this case, we have an executory contract where simultaneous performance is, of course, possible. So Fixture would have no duty to deliver the 25 sets on March 1st at Fixture's place of business unless apartments tenders the contract price for the 25 sets on that date. Question number 10, and the final question in this grouping. The state of Green imposes a tax on the income of each of its residents. As defined in the taxing statute, income includes the fair rental value of the use of any automobile provided by taxpayer's employer for the taxpayer's personal use. The federal government supplies automobiles to some of its employees who are residents in Green so that they may perform their jobs properly. A federal government employee supplied with an automobile for this purpose may also use it for the employee's own personal business. Assume there's no federal legislation on the subject. May the state of Green collect this tax on the fair rental value of the personal use of the automobiles furnished by the federal government to these employees? A. No, because such a tax would be a tax on the United States. B. No, because such a tax would be a tax upon activities performed on behalf of the United States, since the automobiles are primarily used by these federal employees in the discharge of their official duties. C. Yes, because the tax is imposed on the employees rather than on the United States, and the tax does not discriminate against persons who are employed by the United States. Or D. Yes, because an exemption from such state taxes for federal employees would be a denial to others of the equal protection of laws. Take 10 seconds. If you chose option C, you'd be correct. Yes, because the tax is imposed on the employees rather than on the United States, and the tax does not discriminate against persons who are employed by the United States. The rule is that states may not tax federal government activity. However, a non-discriminatory tax, income tax, on an employee of the federal government does not impose a burden on the United States. In this case, the state of Green has imposed a tax on the income of each of its residents, some of whom are employees of the federal government. And income includes the fair rental value of the use of any automobile provided by the taxpayer's employer for the taxpayer's personal use. Since the state tax is not a tax on federal government activity, but rather a non-discriminatory state income tax that happens to be burdening federal government employees, the state of Green may collect this tax. Thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. We upload content every day at 8 a.m. Eastern Standard Time. Please like, ring the notification bell, and subscribe so that you can be updated every time we upload new content, which is usually at 8 a.m. every day of the week Eastern Standard Time.